much, Ms. Tenner. What should we know?
As I said, my name is Ann Tenner, and I'm an attorney with National Health Freedom Action. We're a 501c4 nonprofit corporation that's working to protect maximum health care options for consumers. And we work to protect the right of all people to access the healthcare practitioners and products and the broad range of healing arts that resonate with their path to health and wellness. We respond year-round to calls from individuals and groups throughout the country that wish to promote legal reform, that will respect individual choices. We work with citizens and empower them to take action to address these concerns. And we educate and we train citizens on health freedom principles and on how to develop and pass proactive health freedom legislation in their state that will ensure the rights of consumers to have access to the products that they desire. We also draft model legislation and we testify at hearings and public policy meetings, and we provide strategic support and lobbying assistance to groups in over 30 states and in over 7 countries. We're a member of the U.S. Health Freedom Congress, and we're a founding member of the World Health Freedom Congress. We've attached a list in our electronic submission, and I have copies here of the members of the Health Freedom Congress and a copy of the Declaration of the International Health Freedom Statement signed and supported by those organizations, and 2 resolutions that were passed out of that Congress related to informed consent and to the right to refuse forced vaccines. We became aware of the MDH rule revision proposals from consumers and practitioners contacting us and asking us to explain what this document means for them and their health freedom rights. And we responded by researching and reviewing the recommendations, reading the Sonar report, and we drafted a short action alert for our Minnesota database of contacts to encourage them to submit testimony. Given our work to empower citizens to actively participate in their healthcare decision making and to maximize access to citizen healthcare options, and because our members have an interest in the right to be free from unnecessary and unreasonable government mandates that impact their personal sovereignty as it applies to their healthcare decisions, we are prepared to provide the court and the department with a detailed brief of our legal concerns and the reasons for our opposition to the adoption of the proposed rules.
And you're mindful of the 17th?
Yes.
Excellent.
Yeah.
Ms. Tenner.
NHFA opposes the adoption of the proposed rule revisions governing child care and school immunizations because we believe that the current vaccine policy in this state does not accurately reflect the Supreme Court jurisprudence on liberty interest deprivations. The current Supreme Court jurisprudence suggests that a higher scrutiny standard should be applied to modern vaccination mandates than the rational basis review applied in Jacobson. The seminal case on state immunization policies, Jacobson, was decided back in 1905. There was a decision in 1922, but it really has not been examined in depth since 1905. And since then, the state policies have developed quickly, and essentially the recommendations for mandates have been pretty much handed over to the federal agencies and advisory councils to be dictated by them. Along with that, there have been prohibitions on bringing cases forward at the state level in tort against the manufacturers and the doctors themselves. And while that's been going on, though, non-vaccine related cases have been progressing and have been heard by the Supreme Court. And the Supreme Court came out really strong in protection of liberty interests related to medical treatments and choice of what to do with your body and your healthcare choices. We believe that these personal liberty interests and constitutional protection concepts now need to be applied to the conversation of vaccine public policy on behalf of the personal sovereignty of individuals. We support the analysis that was articulated by Attorney Mary Holland in the Yale Health Law Journal in 2002, and we are submitting a copy of that document today. We believe that strict scrutiny, or at least intermediate scrutiny analysis, should be applied to the government setting of public policy mandates that involve the direct invasion into the human body by puncture of the skin and by injection of foreign substances. We believe that the analysis of liberty interests and due process and liberty interests and equal protection on behalf of Minnesota children is sorely needed.
So counsel, let me just ask you, would not the, however you want to phrase it, the conscientious objection language, I think it's in 121A.15, and I think it's subdivision 3A. Is it D? No. I'm sorry. I guess I'm sorry. It would be subdivision 2. D. D is in 121A.15. There is an opt-out provision. Why would that be sufficient in order to preserve one's liberty interest against receiving any type of vaccine?
Well, we're concerned about the rights of the people who choose to use the exemption,
Okay.
as well as the rights of the children who opt to comply with the mandate. While we're grateful that there is an exemption, and our members across the nation are very supportive of having a wide range of exemptions, we think that the regulations need to, that's just one factor in the analysis,
Okay.
the harm avoidance or testing for people who would be more vulnerable. But we think that the regulations themselves need to stand on their own, and that the existence of an exemption shouldn't necessarily shelter or justify the setting of unnecessary and unreasonable vaccine policy for those who do choose to not use the exemption.
Okay, so I'm just trying to understand, because you made an argument that, the suggestion that a regulation like this might be at odds with the due process and liberty interest protected by the 14th Amendment.
Mm-hmm.
So for someone like me, them's just fighting words.
Mm-hmm.
So you have my undivided attention when you say something like that. And so I'm trying to understand, if under 121A.15 there is an exemption, is there still a liberty interest concern such that, I don't know, 121A.15 might be unconstitutional because it violates the 14th Amendment? That's not enough. Is that the argument that the National Health Freedom Action, have I got that right?
Mm-hmm.
Group is suggesting that notwithstanding what I think the health department or the legislature has tried to do in carving out folks who have genuine good conscience or discomfiture, don't want to either receive vaccines themselves or their children, that still even that would run afoul of the 14th Amendment. Have I got it right?
Mm-hmm.
And tell me why, just so that I understand.
Well, we think that we think, so even though there's an exemption, we think that the informed consent that there are enough informed consent issues for the people who want to comply with the mandate that they are deprived. For the people who exempt out,
Sure.
great, we feel that they're protected. But for the people who are choosing to participate with the mandate, we still don't feel that there are enough protections and enough disclosure.
Their liberty,
justify.
their liberty is implicated because Form Exhibit AK is not clear enough to communicate the nature of their interest. Is that the argument?
That's what, yes, a lot
Okay.
of our members would definitely be in line
if
with
you
that.
didn't write it in red tape, people would understand, be able to avail themselves of their liberty interest.
Yeah.
Okay, great.
Yeah.
Now I understand. Ms. Tenner, I interrupted, so please.
Fine. So we do think that there needs to be, we understand that there's fear that increasing the amount of information that parents receive is out there, because there are statements, and even in the Minnesota Department of Health documents, they say that education isn't working because when people get educated about what's in the vaccines or the dangers of the vaccines, that it might result in lower rates of vaccine injections. But we don't believe that minimizing the truth and using the police power of the government to coerce the parents is the solution. We think that the state needs to acknowledge the vast suffering of the thousands of Minnesota parents who have damaged children, and that there needs to be an assessment of what it will cost to provide medical care to the rising numbers of damaged children in the future, and that the precautionary principle needs to be used to refrain from adding more required injections for children until research is produced on whether the total number of vaccines is the cause of the lowered immunity of the population and the reason why unvaccinated children are documented as being healthier than vaccinated children.
Hold on a second, just to give Julia a chance to catch up. So, eager to hear from you, just a little slower, if you wouldn't mind, Ms. Turner.
Yes, and this will be my last point. We think that the goal of the 1967 Minnesota legislature's enactment of the Minnesota School Immunization Law to not only prevent epidemics, but to also ensure that children are protected against vaccine-preventable diseases is unconstitutional and unwarranted. A state goal to use police power to mandate vaccines because it can protect against vaccine-preventable diseases seems irrational. There are nutrition-preventable diseases, lifestyle-preventable diseases, homeopathic remedy-preventable pandemics, which are well documented in literature. But the state does not consider using the police power to mandate people's nutrition intake or their lifestyle decisions. So why should a state be allowed to favor one approach in its policy on preventable disease? Under the favored approach, an unlimited number of government-mandated vaccines could be administered simply because of the fact that a pharmaceutical manufacturer produced them to prevent a disease. This gives an industry that has no tort liability for its products a great incentive to develop an endless number of vaccines and get the states and request the state's police power to mandate their use without any evidence of the impact of multiple vaccines on the health and safety of the population. There are many ways to shape policy on preventable disease. The state should consider other options and shift the focus from this industry-driven, high-risk policy to a more holistic understanding of the total health concerns at issue. We appreciate the opportunity to provide testimony today and to provide follow-up documents with attachments of our analysis. Thank you for your time.
Thank you, Ms.
We would also argue that the liberty interests for those who choose to comply with the mandate are also being violated under the Equal Protection Clause, not just the due process. We would make an argument that children are being discriminated against in violation of the Equal Protection Clause when there's a vaccination mandate that's exclusively for them and it's not imposed on the larger population when the state's objective is eradication of the disease in the population at large.
Okay.
So even though they're...
It follows from the age requirement.
Well, yes, that they are bearing the burden disproportionately for a state objective that benefits the population at large. So even though there is Supreme Court ruling that says that schools can impose mandates for infectious diseases, there are limits to what the majority can impose on a minority group while leaving itself free of those constraints. So even if it did fail, or even if the mandates fail a rational basis or an intermediate scrutiny test, we think that you could still find that there's a violation under the Equal Protection Clause.